make America slime again. At least that's what Miles Farley wanted to do. Now, this particular guy, Miles, he was granted bail today in court today for the YSL Rico case. This is a very good thing for anyone involved in the Rico case. Everybody is plead out, Gunna, a few more people. For him to actually stay down and stay in jail until he was granted a bond definitely deserves a salute from all the people worldwide. Now, like I said, Miles Farley is granted a $650,000 bond. Now, a lot of people are thinking there's no way that he can get this money, but he only needs to provide 10% to the bail bondsman, so that's $65,000, and then maybe a family friend, anyone can put up property, and that can serve as collateral. Bond collateral pretty much ensures the judge and to the court that he will come back when it's time for trial and things like that. Thing is, his same lawyer, Miles Farley, was the same lawyer who was arrested yesterday for smuggling something inside the Fulton County Sheriff Department. Now, they were saying that they had some unlabeled medicine that wasn't in the correct container, and also they tried to take his phone from him. So while they was trying to take the phone from this lawyer, he threw the phone to another lawyer. In the midst of throwing the phone to the other lawyer, this is when the phone hit a deputy. So that's why he was arrested for tampering. He was arrested for bringing narcotics in, and he was also arrested for the assault on the sheriff. So he didn't hit him. He didn't put his hands on him. He tried to throw the phone. Now, the things that make me go, is why was he trying to hide his phone? Was it A, that he was trying to really smuggle something in for one of these clients? Or B, he's in some type of activity that he's not supposed to be in. So long story short, they definitely took the phone, and he had to spend the night in jail. Now, he was released this morning, and he went to his Instagram page and he said this. He says, "The Fulton County Sheriff Department held me unlawfully in a jail cell at the courthouse all day when I didn't do anything wrong at all. Then took my mugshot at night, and I still look damn good." So he is pretty much out of this case, especially Miles Farley, so they'll charge him for whatever the charges they're trying to give him. But keep in mind, Miles Farley was one of the most innocent. He just created clothing for the YSL group. So it shows the importance of staying down and staying solid, because he could have easily snitched, but for real, I don't think he knew anything. If he's just the person that makes the clothes for YSL, I'm sure he's far away removed from the actual street doing for this YSL or what they're allegedly saying. So now it brings it down. I think it's maybe 12 to 13 people still in this Rico case, including Young Thug. So we'll see what happens. We're coming up on almost a year that they was arrested in an indictment for the Rico. So things need to start shaking up. For the judge to actually grant this bail, since this particular judge, just the way he's moving, he's held in accountability for these particular people, including the lawyers. I thought he would have denied the bond after his lawyer was arrested, but it just shows that they really didn't have nothing on this guy. So it shows a plus for this Rico case. It shows it was flimsy. I definitely can't wait to see what they have against Young Thug.
All right, good afternoon, Your Honor. I mainly rely on Meeks v. State, which is 309 Georgia App 855. That held that a one count of theft by taking was subject to a special demurrer because it was entirely duplicative of another charge that was charged in the same offense. And here, Your Honor, I'm basically asking the court to apply Meeks to this indictment the way it's specifically written. In Meeks, the Georgia Court of Appeals held that the counts were duplicative because they provided no additional facts by which it can be distinguished from the other count, and it alleges neither a different set of facts nor a different date. And so, Your Honor, that's what I allege, that counts 50 and 51 are duplicative of count 49. Count 49 is where Mr. Farley is alleged, along with Mr. Stillwell, Nichols, and Garlington, to have murdered Mr. Drinks. And in that count, they say, the reason why, Your Honor, this is especially duplicative is it says that Mr. Drinks was an associate of a rival gang. So essentially what I'm asking the court here is to find it duplicative, because I know the state's gonna say that a gang activity charge and a murder charge are not duplicative, even if it's that murder that is the basis of the gang charge. But, Your Honor, I think that this can't survive a demurrer under Meeks because they write up count 49 as a gang charge. They just don't write the caption. And, Your Honor, the caption is not what holds, it's the substance. And so here in count 49, the substance is the same as counts 50 and 51. Had they not put in that part where it says an associate of a rival gang, then I get it. There's an extra set of facts that, oh, we're saying you killed this guy, and then in this other count, we're saying you killed him as part of gang activity. But 49 says an associate of a rival gang. So because they wrote that in there, and they didn't have to, that's not part of the malice murder statute by any means, but they chose to allege it that way. And so within the four corners of this indictment, of which Mr. Farley is entitled to an indictment perfect in substance and form, here it's duplicative. Had they not put that, it wouldn't be duplicative. But what I submit to the state, what different fact is alleged in counts 50 and 51 that's not alleged in count 49? Because in count 49, they say it's an associate of a rival gang. So if you say someone has an associate in a rival gang, by inference, you're saying that that person is in a gang. And essentially, count 49 alleges Mr. Farley to be in a gang, and it alleges that the person killed was a rival of the gang that Mr. Farley is supposedly in. So count 50 and count 51 that allege the criminal street gang activity with the murder of Mr. Drinks as the subject matter, Your Honor, those are both duplicative of count 49 because they included count 49 as gang activity. So looking within the four corners of the substance of these three counts, there's nothing different in count 51 or 50 that we don't already have in count 49. For that motion, yes, Judge.
Okay, talk to me about the unconstitutionality of the gang statute.
Sure, Judge. So,
And you understand Supreme Court
I understand, Your Honor. I don't think the Supreme Court's going to consider anything with regards to Mr. Farley because there won't be a conviction. But just out of caution, I do think maybe the United States Supreme Court or possibly some other court might review this, Judge. So I do. Right.
What's your good faith basis for challenge?
Yeah, I can explain that, Judge. The good faith basis is that Rule 418 in combination with the Georgia gang statute just completely flies in the face of the most fundamental aspect of our government, which is checks and balances between the three branches. You know, we have Your Honor representing the judicial branch, we have the state representing the executive branch, and we have myself and the other attorneys representing individuals and people in the state of Georgia. And so how it's supposed to work is that we're supposed to be checking each other, we're supposed to be balancing each other. But what we have here is, Your Honor, Rule 418 just completely circumventing Rule 404B and rendering 404B meaningless and robbing both the people of the state of Georgia and the judicial branches of the state of Georgia of any sort of check on the authority of the state to circumvent the legislature, who's elected by the people of Georgia to write the statutes, who wrote 404B. And Your Honor, under 404B, as the court knows, other acts are not allowed in for propensity. They're only allowed in for limited purposes like intent, motive, absence of mistake.
Wouldn't you agree that it's a different statute promulgated for a different reason?
Exactly, Judge. And what's the huge problem here is that our grand jury proceedings are entirely secret. They're not transcribed, and there is no mechanism for either the people of Georgia or the jurists of Georgia to check the state to stop them from doing what this leaves open to be done. So, for example, which is, Your Honor, they might in bad faith, let's say we have a murder case, and that person accused of murder has an aggravated assault, but there is no other way to introduce that except for propensity. So the judge would say, as the state would know, that, you know, I'm denying your 404B, this is propensity, that's not allowed. Our legislature does not allow propensity. However, 418 does allow propensity. And that's what makes the gang statute and rule in combination with Rule 418 so unconstitutional under the United States Constitution. Because what's to stop the state in a secret, untranscribed grand jury proceeding in bad faith just throw on a gang charge onto the murder charge, then... Right, Your Honor, but there's no one to check them. They're doing it in secret, and it's untranscribed, so there's no one to hold them accountable. We have rules, but without enforcement and accountability, the rule is meaningless. And so 418, in combination with the Georgia gang statute, has made 404B meaningless because all they have to do is throw a gang charge on there in violation of the rules of ethics, which happens from time to time, And they can choose to violate that behind closed doors, untranscribed, and then they can throw up their hands at the end of the trial and say, oh, the directed verdict got granted. We didn't know that was going to happen, wink, wink, but they did know. And the reason they did it and put it on there, even though they knew it would be dismissed by directed verdict, is that so then they can use 418 instead of 404B and then bring in, for example, a past aggravated assault for propensity, which is exactly what the legislature didn't want the state to ever be allowed to do. And so there is no... Right, Your Honor, but if we didn't have the gang statute, then we couldn't accuse someone of gang activity, and then we couldn't apply 418. We would have to apply 404B, and we wouldn't be talking about propensity. But
so you understand that evidence under our evidence code, Title 24, may be used sometimes for differing purposes, right? So, right?
yes, Judge.
So under the gang statute in 418, it's a little different than 404B and the other purposes for which evidence is admitted, right?
Yes.
Okay, all right.
And that's just exactly, it is the existence of that, Your Honor, that I find to be just totally unconstitutional, because now there is no way to do checks and balances. It's just whatever the state wants.
The legislature wrote the gang, or enacted the gang statute, and they enacted 418, right?
Yes.
So they obviously had knowledge of 404B, correct?
Yes.
All right. So, I understand your argument. Is there anything else you wanna put forth?
No, Judge. Just,
okay.
I just ask you to grant that, and then the state can appeal something for once instead of us, appealing everything.
Okay. All right. Ms. Rosenwasser? Any other motions? I think I've dealt with the other. Only one is the 418, and I'm waiting on Mr. Carlson.
Yes, Judge. The only other thing I have that I failed to mention is I did have an amended discovery motion that the state's mostly accommodated, but there's one aspect they're not accommodating that I'd like the court to
What is that?
compel them. They relatively recently, sent out these gang profiles on each of the defendants, and then nowhere in the discovery does it say who wrote those profiles and when they were written. And their written response to my motion says, well, you can just call the law enforcement witnesses. But that's exactly why I need Your Honor to compel them to tell me which law enforcement witness produced which gang profiles and when, because even though the state might try to say that's not exculpatory, the discovery statute says it's not only exculpatory things that they have to give us, but anything that might lead to something exculpatory. So the way they've described this gang profile of Mr. Farley, I think they wrote that up after this case already started, and if that's the case, that definitely impacts, my absolute theory of innocence.
Have you had any conversations with Ms. Rosenwasser or Mr. Smith or anybody else in regards to this issue?
No, Judge, only just through our written responses to the motion.
And why don't you have a conversation with her about that? Madam, or is it that are you all willing to, or can you give him that particular information?
Your Honor, I don't want to speak out of turn. I would just request Mr. Farley contact the I would request Mr. Farley contact the Charleston leaders to get an answer on that. I do not want to speak out of turn without confirming with them. If you'd come up to me about this earlier, I could have relayed that message and
Okay. So why don't you have a conversation with Ms. Love or Ms. Hilton? And then if it continues to be an issue, I'll certainly deal with that, okay?
Yes, Judge.
Hold on. We got Mr. Carlson here who can talk about 418. Do you want to go ahead and finish your 418 argument, sir? And then I can let Mr. Carlson respond to that?
No, Your Honor. Just to perfect the record, I also challenged the gang statute for violating freedom of speech and freedom of association, but I don't have further argument about that. I just have it in my motion. Everything I object to about 418, I've already said to the court.